Okay. We can wait for a few minutes.
Good evening, ladies and gentlemen. Welcome to the University of Hong Kong. I'm Alice Lee, Associate Dean. I'm also teaching intellectual property, and that's why I'm here tonight. So this is our inaugural Hong Kong U lecture in intellectual property law, and we're very honored to have Mr. Tan with us tonight. And before I introduce Mr. Tan, of course, he needs no introduction. But before I do so, I would like to invite my colleague, Mr. Hao Chen Sun, to say a few words about this series of lectures.
Okay, I'll just say a few words about why we founded this lecture series. So in the past few years, Alice and I have seen a rapidly growing interest in intellectual property among our students. And for example, Alice, IP course has been very popular among students, and I've been teaching various subjects on intellectual property. As students have told me about their strong interest in intellectual property. And I also think about the unique role of Hong Kong in promoting intellectual property regionally and internationally as well. For example, Hong Kong is an international hub for merchandising luxury goods as well as fashion goods. So Hong Kong has a very unique role in promoting trademark protection. And in the meantime, Hong Kong has a very strong entertainment industry. So copyright protection is also key for the protection and the promotion of the entertainment industry. And right across the border, Shenzhen has a very strong innovative power. For example, there are many big IT companies such as Huawei, ZTE, and Tencent. And Shenzhen, the rumor goes that Shenzhen will become another Silicon Valley in the near future. So all in all, I think intellectual property has become a very important body of law in this region. And that's why we funded this lecture series. I hope you will enjoy tonight's lecture very much.
Thank you, Hao Chen. We are very honored tonight to have Mr. Tan with us. As I said, I believe Mr. Tan needs no introduction. He's been practicing in intellectual property, especially in PRC, for a very long period of time. As some of you, or most of you might know, he is partner and head of Baker & McKenzie's intellectual property practice group in Hong Kong and China. He also co-leads the firm's luxury and fashion industry practice and works extensively with global brands in many jurisdictions. And he has written many books, actually. I've read some of them, maybe not all, including Trademark Law in the People's Republic of China, Pirates in the Middle Kingdom, The Art of Trademark War, and also Pirates in the Middle Kingdom, the ensuing trademark battle, and many other chapters on intellectual property protection in PRC. So obviously this is a very interesting area, and we would like to hear more from Mr. Tan. So today he will talk about not only the existing legal framework, but also how the PRC legal system, the PRC trademark law, complies with international treaties, the practicalities of registration, use, and enforcement of trademarks in China. Please welcome Mr. Tan.
Thank you. Such an honor. Thank you, Professor Lee and Professor Sun. It's a privilege and honor to be at Hong Kong U, and I've just had a very nice tour of Houchen. I've never actually been here on the premises, and I'm only here because of the kindness of your invitation. I'm aware of that. The title of my talk today is Deliberate, Pirates in the Middle Kingdom. I'm not trying to sell my books here, but I did see the bookstore, so I might try to make a proposal then. But the title of the book's Pirates in the Middle Kingdom, of course, Middle Kingdom is Zhongguo. And my team members and I were working on the third edition. It was really inspired by the title, obviously, Pirates in the Caribbean movie, but also because I practice with the cases in China, I thought it would be a pretty funky title. But my editor actually had a big problem with the title because he wanted, the books in IP to be pretty just, objectively stating what the subject matter was. My career in Singapore, Hong Kong, and China has really been an adventure. I've been in IP field since I graduated from NUS in 1987, before most of you were born, I think. I was very lucky to be hired by my mentor partner then, Winston Z. He's since retired last year, and I was hired to be with the China Practice Group to specialize in IP and in China. My objective today is really very humbly to pass it on. I consider myself very fortunate to be able to practice an area of law, of IP, which I'm very passionate about. I consider myself even more blessed to be in this part of the world because I consider it the most exciting business region in the world. And to be in Hong Kong and China really is to be in the center of IP business universe, if you ask me. So I'm thinking that by sharing my personal story or observations, I can encourage those of you who might be interested in IP to follow this path. And I'm also hoping that you'll be able to invest your energy and efforts towards the development of IP and practice wherever you may choose to practice in the future. The road less traveled. So to immerse oneself in IP law as a career might not be a traditional route. Perhaps it is, in some minds, the road less traveled. It was certainly the case for me in Singapore because in those days, in the late 80s, there were only a handful of law firms that had IP practices. However, I knew very early on that IP was my preferred career, even in law school. I had an IP lecturer called George Wei. George is actually from Hong Kong. He brought so much life to IP that almost 1/3 of my graduating class actually chose to go into IP when they left law school. Today, George Wei is a very esteemed IP judge in Singapore, and I have him to thank for inspiring all of us. I spent the early years of my internship, traineeship, lawyering with firms like Drew & Napier, Rodite Davidson, Donaldson & Birkinshaw. These are firms in Singapore that had IP practices. So my exposure to IP in these firms cemented my resolve to make IP my career. And I think, as they say, once you've tasted IP, there's no turning back. But I do recognize that IP may not be everyone's cup of tea, but it fitted me very well. I love the universe of law, but I equally like the world of technology, creativity, novelty. I consider myself a relatively creative person, so I appreciate the intrinsic value of artistic, musical, literary works. I love the world of brands, logos, symbols, and how it actually all interacted in the choices that we make in our daily lives. And it was actually on this platform that the firm allowed me to build up the luxury and fashion practice group, and that has been very successful in the firm. I love the aesthetics and technology and beauty of the iPhone. It's the first thing I touch in the morning, the last thing I touch in the evening as I go to sleep. Say something about me, I suppose. I'm passionate about the world of IP that we live in, and I want to be able to contribute towards it. That's why I'm here. Now, if you can just step back in time with me, a fish out of water. So having come from Singapore, and I'm sure you can recognize my Singapore slang, and having to immerse myself in Hong Kong and China was truly a very challenging transition. In the early days, I really felt like a fish out of water. For one thing, everything is very quick in Hong Kong and China. People speak, they walk, they drink and eat and do things at a breakneck speed, it seems. Now, working life in Hong Kong and certainly in Baker McKenzie was a constant state of activity and flux. It took some adaptation, but I found myself, being the same. I started walking, talking, eating faster than before. As I came from a common law jurisdiction, I had to grapple with the, differences of the civil law system in China, and that was a very steep learning curve. One country, two systems. At times, it felt like one country, 1,000 systems. I knew very quickly that it wasn't enough to know what the Chinese law said. It's only meaningful when you know how it translated in practice. I had to problem solve the IP disputes that were thrown at me. Through the victories and the losses, I also realized that you cannot always win all of your battles all of the time. However, as they say, you should certainly man up, as they say, and fight, live to fight another day. And that's what I've been doing. So once I reached that point of understanding, about the Chinese system, I felt less angst. I knew that there would always be some solution for the client in some form or another. And I carry that optimism throughout my career. And it is a refreshing philosophy, I would say, because you learn every day. The Chinese world in the 90s. I love the buzz of Hong Kong and China. This is a land of opportunity for anyone who has a drive, the passion, the energy, of course, a whole lot of luck. So pre-1997, I came to Hong Kong and there were jittery bank runs and immigration blues at the various consulates, including the Singapore consulate. This was played out against the very blistery typhoon weather on the night that Hong Kong returned to its motherland. But today, looking out of Hutchison House, where Baker McKenzie is, the Prince of Wales building has been renamed the PLA building. I witnessed morning drills by Chinese soldiers where British soldiers once marched. So this was the world I stepped in. And the Chinese IP world that I stepped in was as follows. I like to compare the China's IP challenge to a walk up the Great Wall. So every step brings you closer to the top, but every time you think that you have scored a victory, there's always a new challenge around the corner. When I started lawyering at Baker McKenzie, it became very clear to me why I was even hired to do IP in China. And that's because almost without exception, every MNC client of the firm with investment in China had an IP problem. And throughout all this time, from those days till now, the protection and enforcement of IP in China continues to be the subject of both domestic and international debate and attention. The IP piracy situation is serious and might be described as endemic. But piracy of IP is a big obstacle to one's business in China and abroad. It often comes with the success of the business, and therefore IP has to be viewed as a cost of business. These are, of course, very well-known personalities in various industries, including movies, music, technology, politics, but no one is immune. So whatever business you may be in, you will be a bit target of piracy. So we had a case for Warner Brothers, is the Harry Potter example. In the pirated version, Harry finds himself married in the later editions of the book, and he was fighting the forces of darkness even then. But if only Harry Potter could fight the piracy in real life to defend himself. The late Premier Deng Xiaoping was also the subject of his daughter's book, and even Chinese leadership was not spared by Chinese pirates who made infringing copies of the book that his daughter had written. One of the first cases that we did for Microsoft and the Business Software Alliance had to do with all the pirated computer disks that were sold throughout the country in the 1990s. With the help of the Chinese copyright authorities, we had a nationwide sweep of all the major retail and warehouse outlets of these bootleg industries, and we had a huge victory. My colleague found himself on the cover of the Chinese Daily after these raids, but I was very happy to remain anonymous because I felt that there were many more fights in store for me. And in those days, Disney had a TV show, the Mickey Mouse and Donald Duck show on Chinese television, and they pulled it off the air because the piracy situation got out of hand. But today, obviously, Disney is poised to open their new Shanghai park very soon. It continues to fight piracy, but the situation, I think, in the Magic Kingdom is better now that they are entering the Middle Kingdom. So it's truly a common fight against what I would call China's latest breed of entrepreneurs. These are the Chinese counterfeiters. So while they might be labeled Chinese counterfeiters, the reality is that many of these counterfeiters are actually well invested by foreign parties. So the problem is not just China-centric, it is a global one. But what is IP in the Chinese world of the Iron Rice Bowl? Many Chinese people that I met in the early years told me that IP is for everyone to share, just as you would with a bowl of rice. You'd be considered selfish if you did not share what you have with your colleagues and your friends. The mindset was that IP was a free-for-all. Some might argue that this is a hangover from the Cultural Revolution. I've come across books that have described IP copying as an elegant offense. So there I was, a common law lawyer in post-Cultural Revolution China, the new China, with every intention of doing the right thing for our clients, which was to fight piracy to preserve their rights. But IP enforcement in those days was seen as a foreign issue involving foreign IP rights. These rights were pitted against the livelihoods of Chinese communities that were trying to make a living. Many of our IP clients in the early 90s had a very softly approach to IP enforcement. To them, it was really 3 steps forward, 2 steps backward. They didn't want any attention to be drawn to their IP issues. Their business partners, in fact, would frown upon it if they had any litigation against Chinese entities. So in many senses, our hands as IP practitioners in the early days were really tied. So I had come from Singapore, a very cosmopolitan modern city, entered China, which had the remnants of an old world of Chinese brands. Friendship stores were where you would encounter, obviously, the few foreign brands in those days high up on the shelves. But that old world quickly disappeared over the 90s into the millennium as China developed an insatiable appetite for foreign brands. The new China, with a younger population, very quickly identified the luxury, sophistication, and freedom that these brands represented. So Hao Chen had mentioned the luxury and fashion sector. This is one sector that had done really well as China woke up to the foreign brands. A little glimpse of some of the pictures of the raids that I did in my early days. These are pictures that we had done on raids, and this is a hole in the wall, as you can see. It's an underground factory with a graveyard shift of workers and very bad ventilation. These factories are really hard to find as they keep shifting locations, and counterfeiters are very smart and very quick to change their identities. So enforcement work can be an adventure of sorts, especially to the young as restless as I was in those days. Our lawyers who went along on these raids, I think, are very brave souls, because these raids can be somewhat risky at times. We have been to factories where there's ammunition, there's knives, there's weapons. We have been trapped in angry mob situations where everyone is pushing and shouting. We have been locked behind doors, not allowed access to toilets, to have our meals. During hostile negotiations, we have been chased at airports and tracked down by counterfeiters to our hotels and issued warnings. In any case, if you do find factories making counterfeits, it's really a jackpot for us and our clients, because we would choose to fight very hard. So China has, for many years, and is still the factory to the world in terms of the legitimate and the counterfeit products that it makes. It used to be that a lot of these products were made for domestic consumption, but this is no longer the case because many of these products are actually exported overseas. So piracy, as the IP lawyers would tell you, is extremely organized and operates as a legitimate business. We have come across factories with very young and very old workers. We have also come across factories with only, staffed by handicapped people. When this happens, it raises a lot of social issues, and the question would be, as an established company, would you be doing the right thing to close down a factory that provided these livelihoods? So the media can sometimes be overzealous in their portrayal of these cases. There are sometimes cottage industries in the mom and pop shops that you see that are part of the supply and distribution chain. While we tend to focus obviously on the factories that make the counterfeits, we also sometimes do look after these intermediaries, as I call them, and the IP laws in China have been amended over the years to allow enforcement against these various intermediaries. This slide shows you some of the movement of counterfeit goods out of the factories onto Chinese ports, and they are shipped around the world. You name it, they will fake it. So we have seen a wide range of goods and services that have been pirated, and this is a sampling. Some of these fake stores are done so well that it will take a while before you realize that the store is not authorized by the foreign brand owner. And I'm sure many of you have read about the cases recently in Shenzhen involving financial institutions and investment houses, where the websites and the offices of these infringers are identical. I'm going to show you this only because it's pretty funny. This is how the world of Baidu, Google, and Yahoo seem to have merged together. But the piracy fight is not against brick-and-mortar factories these days. It's really the new frontier. It's obviously the internet. And this is where the jurisprudence of IP laws is still inadequate. But it's one thing for me to stand here and talk about counterfeit bags, fashion wear, consumer goods. But it's really another thing to talk about counterfeit drugs. Because when it comes to public safety, health and life and death comes into play. The state of piracy. It's very hard to distinguish the real and fake items, so our clients will obviously have to show us what the distinction points are. We have to sometimes conduct selected trainings for our enforcement officials as the situation requires. In my early days, I had to do one raid in Shenzhen for the French company called L'Oreal, and they had a problem with Lancôme. Lancôme is Lanjin in Chinese in those days. It was a brand for cosmetics, and they don't put that brand onto bags. But they had a problem because there were all these bags that had the Lancôme brand. So I happily went to the Shenzhen Gongshangqu, AIC, or Administration for Industry and Commerce, on the morning, and I was going to lodge my complaint with the lady that was Director Yuan. I remember her name. And guess what? To my horror, Madam Yuan had on her shoulder the exact bag we wanted to raid. So it was a bit embarrassing that I had to tell her, if you don't mind, this is actually the complaint that we are making today. I'm not sure where you bought your bag, but you have to destroy it. The law says this. Anyway, long and short of it is that in those days, the law did not provide enough ammunition, and we had to take advantage of the Paris Convention, which allowed well-known marks to be protected. And also we made some use of then the draft and anti-unfair competition law. 反不正当竞争法. Those were the early days. So, but thankfully, Madam Yuan was very progressive. She agreed to conduct the raid, and end of the day, we did give her a new bag, not the Lanjin bag, but something else. So the attitude of the Chinese enforcement officials towards serious and non-serious piracy activities can differ. I mentioned to you the life and death cases. Actually, in the Mao Tai case, the death penalty was issued because in that case, it was not just IP violations, there was actually fraud issues. But many of our clients in the drugs and alcohol and tobacco industries, they face very, very difficult cases. Just to show you the sense of the mindset, I had to go to Luohu, and Shenzhen, because that's, at the doorstep of Hong Kong and China, where there's a huge mall that had all these counterfeit items being sold at the Luohu Shangyechen. And I had to go with a French client to see the Shenzhen mayor because they had a problem, with the counterfeits that were being sold at the mall. So I remember this meeting very well because it gave me a very good sense of where things are and how the officials look at, how the luxury industry is. We made our complaint, and the mayor looked at the complaint and he said to us, can you tell me how much this wallet is worth? Because we had given him a wallet as a sample. And when we told him how much it was worth, he put it on the table and said, this is way too expensive. And by the way, the piracy that you're complaining about, it's not an issue because if you actually look out the window, people are lining up outside your stores, and these are all your future consumers. The fact that they, have such a the fact that the brand is so widely accepted means that you don't have to worry about it. If they're pirated goods, they are good advertising for you. So what is the harm that's being caused to you? So when you're faced with a situation where you have to show more than social harm, public safety issues, then it's more difficult. This is a map of China, and I like to compare it to the map of the United States. So in the IP world, Beijing is like Washington. Because in Washington, you're close to the seat of power, they're very compliant. So most of my cases up there are pretty easy. Shanghai is like New York. It's very trendy, maverick, sophisticated, playful even. And for those cases, sometimes it's a luck of a draw. And I do get good results, but you have to maybe be a bit more aggressive. Guangzhou is Texas. It's the wild, wild east. This is where the infringers are blatant, arrogant, and even reckless at times. But this is sort of a little analogy, I guess, that I can make. WTO accession, December 2001. Seems like a long time ago, but this was a turning point because it paved the way for a more progressive IP system in China. But it wasn't the magic wand trade agreement that swept away all the privacy issues, but what it did have was the TRIPS agreement. And you can see it up here, what it stands for. So TRIPS holds China to a higher and more international standard of legal compliance for its IP laws. And for me, that meant quicker justice, more transparency of the judicial system, and hopefully I could get better results for my clients. I won't be going to the nuts and bolts of the law today, but China has one of the best IPR laws in the region, if not the world. So all the laws you can think of, trademarks, patents, copyright, anti-unfair competition, consumer law, industry-specific, region-specific laws. So for someone from a common law jurisdiction, I found myself lost in a jungle of laws and regulations and trying to figure out which one I should use and which one made a difference. And enforcement of these laws is really hard to say because it could be weak because of the lack of supporting structure or a mere ignorance of the law. If you remember nothing from my talk today, just remember this slide. Okay, this is the slide that I use to describe my job. My job on any given day, as I try to resolve the IP problems together with my team members for my MNC clients, is to figure out which city to litigate. Forum shopping, as they say. Is it at national level, provincial, regional, or local? Which building to go to? And there are many IP bureaucracies, and there's no one-stop shop. So if it's trademarks, you go to the trademark department, the AIC. Copyright, you go to the Copyright Bureau. Patents, Patent Management Bureau. They need to figure out which floor to go to. There are many divisions within each bureaucracy. And then the most important thing, which person to look for. The official and the Mr. Nice guy who does an honest living and would be able to help you. So this is, in a nutshell, the struggle of IP enforcement in China. Key concerns in IP enforcement, obviously the size of the country is huge. The knowledge of the laws, it's a very trickle-down effect. The laws may have come out for months and someone may not have heard of it at a lower level. It's a huge country. The logistics of organizing any enforcement action can be challenging. And of course, the IP bureaucracies have a manpower issue. And for want of a better word, protectionism is at play. And this can be difficult in the wild, wild east, as I told you just now. Some stories that I have to share with you. In the early days, there was one case that we did for Unilever, and this had to do with their shampoo brand, Tianmei, or Timote. This was in Guangzhou province. The infringer took the trouble to carve out the Tianmei word onto a rock, and he poured all kinds of chemicals over it to age the rock. And the story that he came up with when we took action against him was that he was inspired by the stone in his garden. So we had to get an archaeologist to test it out, and it turned out to be total nonsense. There's another case that we had where we had fake evidence of newspapers. So sometimes the counterfeiters get very creative. Once someone actually printed old newspapers as proof to the court, they actually notarized and legalized it. And they use it to show that they had come up with the brand name themselves. They actually printed the newspapers by themselves. But IP laws don't always provide the holistic solution to IP disputes. So we have to think outside the box. And that's where creativity comes in. And we're thankful for the system in China which allows for this creativity. We have made use of tax laws because piracy is tax evasion. We have looked into labor laws because in some places, as you have seen from my slides, there is some labor issues. There's sometimes environmental issues, advertising, labeling, all kinds of other issues. One thing which is you should note about China is a Chinese-speaking jurisdiction. So the Chinese language governs if you're practicing or advising on Chinese law. Many of our foreign IP clients only have foreign language marks, and they leave the Chinese versions to their business counterparts in the region. Obviously, this is not good because we don't take ownership of Chinese brands. There could be Chinese versions of your foreign brands that would come into play. It's best practice to have a Chinese brand that carries the DNA of your company, your core values, and of course it's a plus if the Chinese brand sounds like your foreign brand when spoken. The best brand I can think of is, of course, Coca-Cola, because Coca-Cola sounds like Coca-Cola, and also it has fantastic meanings when it comes to thinking of quenching your thirst. So as lawyers, my job is to ensure that our clients' Chinese language marks are properly chosen and protected in all the Chinese-speaking jurisdictions throughout Asia. It makes sense to have one consistent version. Otherwise, you get lost in translation, and there have been many funny examples where the Chinese dialects of the Chinese marks are very inferior or negative, and this has been a problem. But translation, as they say, is an art, it's not a science. So this is where the lawyers step out and the branding experts come in to help our clients devise and protect a Chinese mark. The example that people always give is of the Quaker mark. There's no authorized version of the Chinese mark when they first entered China. So the Chinese consumers looked at this Quaker man and decided that it was Lao Ren Pai, which is old man brand, right? So that Chinese nickname stuck, and the Quaker company had to adopt it as a secondary mark for China. Their actual Chinese mark is, of course, Quaker, which is a Chinese transliteration of the English Quaker mark. And then the Ralph Lauren mark, consumers referred to this as a three-legged horse with a man on the horseback. San Jiao Ma, right? So this is a Chinese nickname. And I think these days I spoke to some colleagues who knew about Ralph Lauren, and they said that there are many Chinese versions in place. They don't actually actively use any one in particular. I'm going to focus a bit on administrative actions that we do. We have to be realistic. We have to take very quick and commercial action. We need a war path and strategy because there are a lot of pirates at play. This is a little clip that I want to show you from the press.
再来说一说打假，这个打假里面呀，奢侈品是一个重灾区啊 ，A 货泛滥。大街小巷呢，不管是青春美少女还是卖菜大妈啊，清一色背的都是 LV 啊、香奈儿的包包。就算是买了一个真的，别人呢都可能以为是个假的。那么最近，广州警方就端掉了一个特大假冒奢侈品的售制团伙，涉案金额呢是超过了2.3亿元。那么这些高仿的假冒奢侈品呢，连这个条码和证书都做的是以假乱真啊，行家都是难辨真假。
假 LV、香奈儿手袋、假劳力士、欧米茄名表、假化妆品，连名车配件都是假的。据警方说，有些假冒商品甚至要请专家到场，用放大镜才能分辨得出来。像这些 LV、GUCCI 的皮包，连包装盒和证书都是按照真品仿制的。而那些假名表，不论外观的打磨、字体的饱满度，还是指针的粗细，平日里对名表没什么研究的街坊，还真难看出个所以然。短短1个月时间，广州警方就陆续在
Okay, it's a bit long, but I will just stop there. So, we have to choose the enforcement options carefully, and one of the options that we have is to do what we call administrative raids. So the beauty of this is that it's quick justice. We can file the complaints in the morning, as I mentioned to you, the Lancome case, and normally these raids are done before lunchtime because these guys have to eat, and they don't carry on beyond lunchtime. And there would be a decision that would come out in 3 months. And normally for us, it's to clear the marketplace, but it's really a slap on the wrist where infringers are concerned. So there's no pain that they actually feel. These are examples of raids that we have done, just to show you. But I think for the bang for the buck for our clients, we have to consider litigating in civil actions in the Chinese people's courts, because that's where you actually can get better compensation, and there are statutory damages which are set out by the laws. You can get asset preservation, you can get ex parte seizure of assets, there are bond requirements, you can get injunctions, and a very Chinese thing, you can actually get a public apology in the newspapers. And then, of course, you can consider criminal actions, and this is where I think this is truly the bang for the buck, because then you get infringers, assuming they're the right ones, behind bars. And with this, it's quite difficult because the Gong'anju, the Public Security Bureau, they are the new kids on the block when it comes to IP bureaucracies. The Gongshanju are the ones that have been around for a long time, the Banquanju, Zhuang Liju, those people have been around for a long time, but when it comes to the Dong Anju, they used to be doing things like kidnapping, murder cases, whereas now they're doing IP cases. And the good news is that there's now criminal liability standards which are set up by the IP laws and criminal laws, so the infringers can be sentenced up to life in jail and levied with very high criminal fines. There are specialized IP courts that have been set up in major cities to handle IP cases. But China is a self-help jurisdiction. Registration is king. So if you have no paperwork to show your rights, it is difficult. The burden is on brand owners to help themselves, whether it's getting evidence, choosing the bureaucracy, or following up on the leads. The discovery is very bad, and you have to go the extra mile yourself. So the best practices in IP audit that we normally would ask our clients to do is to consider the big picture, to have a really good plan, and to target all levels of production and distribution. And of course, there are a lot of cross-border issues. Sometimes if you can't fight in China, fight in Hong Kong, or fight in Taiwan, or fight in other parts of the world where there might be other links. And many of our clients have over the years considered anti-counterfeiting and technology to fight piracy. But the truth is, the catch-up is just a couple of months, and whatever you come up with, whether it's holograms or special packaging, they usually would catch up very quickly and do the same thing. Investigate and navigate. This is important. I'm only a lawyer. I need my investigators, and very good ones, to get the evidence for me. And it's important to choose very good investigators because there are good and bad ones out there. Slime, crime, nickels and dimes. What I mean here is you have to follow the money. So the strategy is always to find out where the money is and to have a chain to disrupt the infringer's business. And pay attention to PR strategies. This is the governor, obviously. Many years ago, he was helping Hong Kong to fight piracy. I guess needs to be an ambassador of sorts for it. We had a case in China where several automobile companies like Volvo, Honda, and BMW, they got together to fight this infringer in Jieyang. There's this place in Guangdong province. And there was a lot of pressure that was put by the media onto the very well-connected infringer. And when we went to court that day, it was and it's exactly what you see in the movies, it's kind of the triads in one corner and lawyers on the other side. It was pretty frightening for our clients who were wondering whether they did the right thing. Of course they did, because at the end of the day, with a lot of pressure, the infringer ended up in jail, and we had a good result, but it took a long while. If you do get seizures of counterfeit products, what's very common is these destruction ceremonies. This is quite common, and you do it with a lot of fanfare, with a lot of press, and you get positive publicity out of it. This is a picture taken by one of my colleagues who was obviously enjoying a cigar to celebrate the destruction of the counterfeit goods, I think. I wanted to highlight the QBPC. This is a Quality Brands Protection Committee. This is a group of many multinational companies who have IP issues in China. So you do not need to be alone. You can fight together as a group, and MNCs have done that. I think they're about maybe 8 or 9 years old by now. The history of the QPBC has been very positive, and it gives a lot of credibility to the IP fight that you have in China. Another clip for you.
星巴克、檀木奖，这些都是大家耳熟能详的驰名商标。但是您听说过莫巴克盐木匠吗？近日就有网友爆出，蓟县有条山寨一条街，沿街的铺面招牌全是山寨版。近日，网友将自己在蓟县西站附近某街道上的所见发上自己的微博，类似星巴克、伊藤洋华堂、檀木匠等大家耳熟能详的驰名商标，在这里都有了一个山寨版。微博一经发布，引发网友吐槽。有网友说被雷的外焦里嫩。记者根据指引来到网友所说的这条山寨一条街，亲眼见识一把。眼前这个商标是不是很熟悉呢？没错，乍一看的确会以为这就是以梳子为主要产品的著名品牌檀木匠。再仔细一看，不对呀，檀字右边的秦怎么不见踪影了呢？成了盐木匠。这一类山寨商标，我们归纳为用别字。同样的办法，豪克莱变成了豪克莱，星巴克变成了莫巴克。还有一类山寨模仿就是调换文字顺序。
Apologies.
益阳藤华堂、人乐人、屈臣氏、永和豆浆。这样看起来虽然简单，但却成功利用了人们的惯性思维，第一眼看过去还真分不清。还有一种山寨就是换图案， 李小龙拥有真功夫，但是真功夫不一定拥有李小龙。真功夫的商标图案是一位长相酷似李小龙的人，而在蓟县这条山寨商标街道中，头像被换成了漫画，可谓吸引人。有关负责人表示，给每个铺面挂上山寨招牌，是希望能够营造良好的商业氛围。
So it can be very comical at times. Truly is quite comical. Some high-profile cases that we have done in recent years, I just want to highlight some of them for your attention. So this was in the fashion industry. We had 5 fashion brands, LV, Gucci, Burberry, Prada, Chanel. They came together to fight the landlords of the Xiushuijie in Beijing. This was a notorious silk market. This is many years ago. I'm not sure whether you guys have ever seen it because you're so young. But they're right outside the embassies in Beijing. And it's interesting that, it's within stone's throw of all these consulates who couldn't do nothing. So all these luxury companies came together, and because the IP laws didn't give us enough ammunition, we made use of the real property laws. And one of my partners then got together a very concerted effort. At the end of the day, this was in 2005, 2006, we had the Higher People's Court that confirmed that the landlord was liable, and they had to stop infringements by giving notice to the vendors. So I guess the lesson here is to look beyond IP law, to fight as a group, and to lobby and get media support. These days, the silk market has been relocated to a building not too far away from the previous Xiushuijie. I think they have a different mode of operation today. I haven't been there for a while, but the problem obviously has not gone away completely, but at least it's less visible, and for our clients, that's a good thing. So the Starbucks case in Shanghai is worth mentioning. This was in 2005, sorry. And this was a case where the Shanghai People's Intermediate Court recognized Starbucks and the Chinese version, which is Xingbake, as well-known marks. And the infringer was asked to cease infringement and compensate 500,000 RMB, which was the statutory damages in those days. And this was confirmed on appeal. So what's interesting about this case, and it actually was reported on CNN, that's how I knew the decision came out. I knew it first on CNN before I actually got it from the authorities. There was a long-standing conflict between trademarks and trade names, and there was one issue which they had to resolve. And in those days, unfair competition was quite a hot legal tool, and it was being used for this case. It was the first time that the Chinese courts actually acknowledged that a Chinese version of a foreign brand, which was Xingbake for Starbucks, was a well-known mark. And they made use also of the Paris Convention and the TRIPS arguments. And it took a while before the decision came out, and I was wondering why. But years later, I found out why, because one of my colleagues who joined Baker McKenzie in Shanghai, she used to be an ex-judge, and she turns out to be one of the judges in this case. And we actually hired her years later, not knowing that one day our paths would cross. And she told me that there was a lot of pressure, obviously, in making the right decision because this was a foreign brand seeking recognition in China. But you stop one infringer, another one appears. The success of the earlier cases obviously makes it easier for Starbucks to argue for stronger enforcement in future cases, but there's no precedent system in the civil law system, so like cases with similar facts do not guarantee equal results. In the meantime, Starbucks continues to expand widely in China, and this continues to breed a lot of lookalike shops who want to make quick profit from the strong reputation of Starbucks. But it's much easier these days to clamp them down. Now, another case worth mentioning is the Harley-Davidson case. This is a case which is quite interesting because this guy set up his own Harley-Davidson shop, even though he didn't have the license. He smuggles these Harley-Davidson bikes from Japan into China. It took a few years to fight him, which is a long time, because he was so well connected. He actually went on CNN and gave an interview to the reporters then, and he pretended to be an authorized distributor of Harley-Davidson, and everyone believed him. Of course, we knew better. But the lesson here is really, as I used the analogy of climbing up the Great Wall, do not stop climbing because the perseverance that you give will finally win the day. So everything I've told you about what I've experienced is just a snapshot. I could not achieve it without all the team members I have at Baker McKenzie. This is a selfie that we took in Penang, Malaysia recently when we won some awards in recognition of the clients that we serve. And I hope you don't mind, Hao Chen, I wanted to do a bit of editorial here for Baker McKenzie, because we are very passionate about IP in the firm, and we think that we rock because, of our brand name and reputation. We have a very loyal and stable IP client base. It really is recession-proof. I never really have to worry very much about getting too many clients. I worry about doing the right job, keeping my clients. Leadership structure is very stable, and, the rest of the bullet points you can read. Some of my team members are here, and I'm very pleased that they are here to acknowledge also your invitation to me. We can tell you about this. So in conclusion, I would simply say that thank you for spending time this evening to listen to my story of IP. If you're planning to embark on the same journey, you can be assured, I think, of a very rewarding, very interesting career ahead of you. And for me, because I want to pass it on, I'll be very happy to help you in any way that I can. And I'm sure Professor Sun would do the same. Thank you.
Thank you very much, Mr. Tan. We still have some time for questions.